Hi everyone. Hope you're doing well today. So we are going to be talking about the new updates on the parole in place because a lot happened in a week. A lot happened in a week, so we want to talk about that. If you usually join me on my lives, you know I am doing this an hour earlier than I usually do, and that is because school is back in session and you know, early release and all of that is happening. So I have to pick up my kid in an hour. So instead of not doing a live and not giving you this update, I am coming in an hour earlier, just so you have all the updates of what's going on. Hi, Mary. Thank you for joining me. Um, so updates. As you all know, on August 19th, the new parole in place went into effect. USCIS was accepting applications. You were able to file your application online, pay the fee, all of that. And within that week, we were already getting reports from other lawyers that filed on that day one that their applications were being approved. Okay, within a week. And those were for people that already had their biometrics. So people that already went and did their fingerprint because of a different application, and people that have an I-601A waiver pending. Like I told you before, those applications are getting priority. And that's what we were seeing on that day one. So on day one, people were filing, and within that week, we were seeing cases being approved for people that had a 601A waiver because they already did their biometrics. Okay, that was then. And then on Friday of that week, we got notification that the Attorney General of Texas and 15 other states, so it'll be 16 including Texas, already filed a lawsuit trying to block the parole in place within a week. All right. By Friday, we already got that notification that they filed something, but we wouldn't be able to see it until that Monday. So on August 26th, that application was accepted and is being run through the federal court in Texas. And guess what happened on the 26th? They also asked for an injunction. When this whole thing came out, if you go back to that video, I did mention that there is potentially going to be a lawsuit and there is potentially going to be an injunction. Okay, that's just how all of these things work. When the Biden administration did the parole for the countries, the Haiti parole and all of that, there was a lawsuit by the same attorney generals. I'm just saying, okay? By the same attorney generals, they filed a lawsuit and they lost that lawsuit. So I am hoping that they lose this one as well. But let's talk about what they asked for. When they filed the lawsuit, they asked for an injunction, basically asking the court to order the government not to approve any cases or even accept any applications. So not only do they not want people to be able to apply for this, they're saying if you already applied, the judge should stop them from approving the case. And unfortunately, the judge agreed to one of it. The judge said, hey, USCIS, you cannot approve any applications for at least 14 days. So that's 14 days from August 26th. So we're going to be well into September when the judge is going to make their decision, their final decision. So for the next 14 days, USCIS cannot approve any parole in place applications. So if you're already filed, know that yes, they accepted your application. Yes, it's in there, but they can't actually approve it even if you meet all the requirements, at least for the next 14 days. However, what the judge also did, so the judge says USCIS cannot approve any applications, but then they also said USCIS can accept applications. So they can't approve it, but people can still file for this. And we're going to talk about whether you should still file or not. So you can still file for this. It's just you're not going to get any decisions in the next 2 weeks, basically. Okay. You're not going to get any decisions for 14 days until this judge reviews all the filings, all the arguments, and makes a final decision. Now, let's talk about what those final decisions could be, right? We have best case scenarios, and then we, of course, always have worst case scenarios because this is something that's out of our hands. It's in front of a federal judge, and the federal judge is going to make those decisions. All right. So, was it expected that there will be a lawsuit? Yes. Was it expected that there may be an injunction? Absolutely, at least on the lawyer's end. And I did try to warn y'all about that. But it is what I'm recommending to my clients. Again, what I'm recommending to my clients is that if you qualify, still go ahead and apply. Okay? Because you can still file for the application, but you will not receive a decision for at least 14 days and possibly until mid-October. Because if the judge comes back and extends the injunction after reviewing all the arguments, the final decision may come in mid-October. So we really want to give you realistic expectations of what the arguments are, what is, what's going on here. So if that is the case, if we're waiting till mid-October, there's certain things that could happen, right? I'll start with the best case scenario, right? The best case scenario, which is what I want. We all want the best case scenario, is that the judge basically says the program can move forward. USCIS can accept applications and approve applications. That is the best case scenario, and that's what we all want when it comes to this. Of course, the attorney generals, the 16 attorney generals that filed the lawsuit, don't want that. But this will be, like I always said, the parole in place is something that is going to be extremely beneficial to U.S. citizens that have a spouse that is not in the U.S. with documentation or that entered the U.S. without authorization. That is really important to keep in mind here. It's not just giving people status, it's giving U.S. citizens a path to having their family stay together and not have to leave the U.S. Okay. So best case scenario, the program is unpaused and everything can be approved and USCIS can just move forward with their applications. All right, that's the absolute best case scenario. The next best case scenario is that the pause could be continued until October. So after the 14 days, the judge can say, hey, I want to go ahead and extend this injunction and continue this pause until I make my final decision. And also, if this happens, you can still file, but you will not receive a decision until that mid-October. So that's the second. And then the third best case scenario, right, is that the judge basically makes a decision, a final decision where they say, hey, this program has to stop. But if someone already applied for it, USCIS, you can go ahead and approve those applications if they qualified at the time they filed. Okay, so it's not the best case because they're basically saying if you miss the window to file, your application cannot be even considered. So they can basically say, hey, if you already filed, USCIS, you can only deal with the people that already filed before I made this final decision, but you cannot take on new applications. And then the worst Worst case scenario is that the judge comes back and says, hey, the whole program is scrapped, right? You can't approve applications and you cannot take new applications. That's the absolute worst case scenario. We do not want the worst case scenario because, again, this program is meant to change the lives of US citizens that have, some of them have already applied for an I-601A waiver and are waiting for that to be approved, or they're waiting for an interview at the embassy and they don't want their spouse to have to leave the US to go to an interview and then only come back once that visa is approved. They do not want that family separation. So because of that, this program was created and we want this program to run. So again, the best case scenario is that the judge comes back in 14 days, or at least when they make their final decisions and say, hey, 16 attorney generals, nice try, but I don't believe you, right? This program is not harming your state, so we can go ahead and let USCIS continue running the program. Absolute worst case scenario is that they say, hey, USCIS, you have to shut down this program. You cannot move forward. You cannot process the applications you have, and you cannot take on new applications. So that's the best case and the worst case. And then I guess the medium case is where they the judges say, hey, USCIS, you cannot take on new applications, but you can approve the ones that already filed, which is why my recommendation is to allow people to file, right? That's what I recommend to my clients is, yes, this lawsuit is not great, but if the medium case scenario is what we get, you want to at least have your application already in there. Okay? You don't want to be, regretting that you didn't file because a judge comes back and says, hey, if you already filed, your application can be processed, but if you haven't filed, too bad, you're out of luck, right? You don't want that. So you want to make sure that you are filing if you qualify, looking at all your options. I know people that already filed an I-601A waiver or already have it approved and are just waiting for an interview. They may just choose to go to their interview outside of the US. But if you haven't started that process and you know that process can take 3 years just for the waiver alone, that may be an incentive for you to go ahead and apply and basically hope for the best case and the medium case scenario, right? So that is the update. We are going to be watching this very closely and seeing what the judges decide to do, if they decide to extend the injunction after the 14 days, or if they decide to go ahead and wait till they make a final decision. So again, arguments are being made by the US government and arguments are being made by the attorney generals bringing the lawsuit, and there are interested parties, other legal organizations that are filing opinion pieces with the court. So there's a lot of arguments being had in this case on both sides, right? People that wanted to move forward and the attorney generals that don't want it to move forward. So we, this is not the end. We are going to be having more information, and the judges are going to be making a decision hopefully soon, but at least by October, we should have more information on how they want to move forward with this. So if you have questions, put them in the comments. Mary, I already see your question and I'm going to get to that next. If you're watching this on the replay and you have questions, put it in the comments as well. Again, this is just a lot happened this week with the cases, so I wanted to make sure that I cover that. If you guys want me to actually go through the legal arguments that's being made on both sides, feel free to let me know in the comments. I'm happy to break it down. And we can also compare it to the legal arguments that were made with the other parole program as well. So let me know if you want to do that. Now let's get to Mary's question. So, a friend recently filed for VAWA and they are separated. Can she file for parole? She came here legally. Okay, so the parole is only for people that entered the US without inspection, meaning they did not come here with a visa, with any sort of permission from the US government to come into the US. Okay, so if they entered with a visa, they entered legally into the US, they would not qualify for this parole. And this parole does not give them a green card. I want to also make that clear. So this parole just gives them a legal entry into the US so that they can then apply for a green card through their spouse. It does not give them a green card. So for your friend, you know, if they had a legal entry and they're married to a US citizen and they're applying for VAWA, they can already apply for a green card application with a work permit and all of that. They don't have to go through this parole program just to go ahead and do that. Okay, they can already do their VAWA, they can already apply for a green card and already apply for a work permit. Okay, so that's a great question, and I'm glad you asked that because a lot of people have that confusion of whether someone that came here with documentation can apply for this. No, you have to have entered without any permission, and then you can apply for the parole. But if you did enter with a visa and you're applying for VAWA, like that question asked, you would be able to continue with your VAWA application because you had the legal entry into the US. I hope that answers your question. If anyone else has any questions, feel free to put them in the comments. I know I'm live earlier than usual, so I appreciate you all joining me, okay? I know this is not my typical time. All right, great question. Does VAWA RFE have an expiration date? It depends. So some RFEs will actually have the expiration date on it. Some VAWA RFEs do not have an expiration date on it. You do want to send it in as soon as possible. The response should be sent in as soon as you possibly can. Typically with RFEs, the time frame that you're given is 87 days, right? That's just the typical RFE timeline that you're given. With VAWA RFEs, sometimes USCIS does not put a date on it because, again, it's a VAWA application. They want to give the applicant as much time as possible to get that information to them. And they know that in certain abusive situations, the person may not have access to that documentation immediately. So it's harder for them to put, a strict deadline on things. But there are situations where USCIS will put a deadline and it's typically on the VAWA RFE. Okay, so it's either going to be the 87 days or they will put like an exact date. If there's no reference to, 87 days or the exact date that they want the response by, sometimes, again, I have seen where it's kind of an open-ended one, but if there's no open-ended, so if it's open-ended, you want to still try to get it in by that 87 days just to give yourself, more room there. And you don't want to miss any unknown deadline that USCIS may have had on their end, but they didn't put on the paperwork. So typically you want to get it done 87 days, but if there's no actual hard deadline on the RFE, you may get away with more time. Okay. So if you have any more questions, please put them in the comments. And if you are just joining me, we were just talking about the parole in place and the lawsuit by 16 attorney generals that basically resulted in the federal judges pausing the program where you can no longer, where USCIS, I should say, USCIS can no longer approve applications. They can only accept applications. So they can take in the applications, but they cannot approve it until this injunction is over or until the federal judges make a final decision of whether the program should continue, not continue, or something in the middle. Okay. Best case scenario is that they come back and say, USCIS, continue your program. You can approve applications. You can take in applications. Worst case scenario is they come back and say, USCIS, you cannot take in any applications and you cannot approve the applications you already have. And then the medium case scenario is where they say, hey, USCIS, you cannot take in any new applications. No one else can file, but the applications you already received before we made this decision, you can still process those and approve them if the person qualifies. So it's really, really important to keep that in mind, that there are, different levels of things that can happen with this lawsuit. Obviously, we want the best case scenario where they say, USCIS, you can go ahead and process all of these applications, approve them, and just do everything with them that you need to do to run the program. That's what we want. But if, let's say, it's the medium case scenario that happens, you want to make sure that you have your application filed before that final decision, because if you miss that cutoff time, your application will not be accepted and will not be processed. So definitely in my office, we are recommending to our clients that qualify to go ahead and apply, because it may end up being that medium case scenario. And if it ends up being that, at least you already have your application in, and USCIS will still have to process it. And that, again, typically, because that's kind of what happened with DACA a little bit. All right. They can't take on new applications, but guess what? The people that got approved can keep renewing their DACA. Think about it that way, right? So if you missed the boat with the DACA applications and, the judges say, no more, you can't approve new ones. But if you already have it, you can keep renewing it. Right? So it can end up being something like that, where they say, hey, you can't accept new applications, but if the person already filed, you can go ahead and process those applications. So that is the medium case scenario. We want the best case scenario, but honestly, the medium is better than nothing. Okay? The medium is better than the worst. So if you're still on the fence of whether to file, especially in light of the lawsuit, I hope that helps you in making a decision one way or the other on whether to file or not. If you have questions, go ahead and put them in the comments. If you're watching this on the replay, hi, welcome, and go ahead and put your questions in the comments as well. Again, I'm so glad that you guys are joining me, because I am doing this live an hour earlier than usual. So I'm glad I was able to catch some of you live. So ask me questions. All right. So I see a question from Instagram. I had a ticket but was unable to settle it online. So I settled it in court for a fine of $280 for failure to present registration. Would it impact my green card when my spouse files for me? So typically a traffic violation on its own would not do anything. You do have to disclose it. So there's a question on the green card application that asks if you have been charged, cited, arrested, right, So this will most likely count as a citation. So you would need to disclose it with documentation showing how it was resolved. But is having a ticket for $280 where there's no aggravating factors like a DUI or anything like that? Typically, no. But you do have to disclose it and present documentation showing what the outcome was. So just showing that you just had to pay the fine and there was nothing else beyond that. You do have to do that. But as far as the impact on whether you can get a green card or not because of it, it's not. The risk is very low on that. Okay. All right. So any other questions? You have me here live, at least for the next 5 minutes. Before I have to go pick up my son from the bus. So ask me your questions and we can, if I don't see any questions, I'm going to end the live early and I will see y'all next week at the normal time. And like I said before, if you guys want me to go through the lawsuit and the arguments for the lawsuit, comparing it to the arguments that these same attorney generals made with the Haitian Honduras parole program, that lawsuit that was dismissed, right? That they didn't win. We can compare the two and talk about what we think will happen based on that. So make sure if you are interested in that or if you think that's something you want to know more about, let me know in the comments and I will do that video for you all. All right, so I see another question. All right, I filed for U visa 6 years ago and end of last year they sent me a letter saying that they don't have a visa available for me. They will let me know. Should I wait or there is something else I can do? You have to wait. Honestly, you have to wait. So basically what they mean by that is they are going to approve your U visa, right? They are going to approve your U visa. But because there's a limited number of visas available every single year, there's no visa available today to give to you, but your U visa is essentially approved. That's what that means. So all you really have to do is wait. It is a long wait. You should have received like a deferred action with a work permit and all of that. It is a long wait. I believe the U visa wait time right now is around 14, 15 years. I know, years. But all you can really do is wait until you get that U visa. And then once it's approved, once they can actually give you the visa, you would then be able to just wait 3 years and apply for a green card. But it is a long wait and you should have gotten a work permit while you're waiting for that time frame to go by. But there's not really anything you can do to speed it up because, again, remember, the way I like to think about it is there's people that filed, 14 years ago that still don't have it because they're waiting for a visa to become available. So unless you have a situation that trumps everyone else that's waiting before you, USCIS is not going to make any moves to take a visa away from someone else and give it to you. That's just not how it works. So you just have to wait, but it is a good thing. That letter is a letter that everyone that applies for a U visa wants to receive. Okay, everyone that applies for a U visa wants to receive that letter saying that there's no visa available right now, because that means once there's a visa available, you're getting one of them. Okay, so that's a good thing. I know the wait time is long, but that's a good thing when you get that. All right. All right. So if you have any questions, put them in the comments. So happy that I was able to jump on live today and talk to you all. I do not see any new comments, and I do have to run. So thank y'all again for joining me. If you need immigration assistance, if you want to know if you qualify, what your situation is, what you can do to get your green card, your citizenship, go ahead and schedule a strategy session with me. You can do that by going to my website, lilylegal.com, and clicking on contact us. That way, we can talk and see the best way to assist you and how I can help you in your journey. And you can also call my office at 508-443-1788 to see the best way I can help you and schedule a strategy session. All right. Euphoria, you got in the nick of time. How do you apply for a 90-day visa coming from Zambia to New York? So your fiance will start the process with an I-129F. So if you are so the fiance that's the U.S. citizen will start that application process, not the person that's in Zambia. So that's the first step, is applying for that visa. And then once that I-129F is approved, then you can do the DS-160, attend the interview, and once approved, you can come to the US. And then once you're in the US, remember you have to get married within 90 days, or I've seen people not get married within 90 days and have to do the I-130 and the green card application all over again. So just make sure you get married within that 90 days and apply for your green card. But like I said, first step is your US citizen fiance starting that process. It's not something you can do if you are the non-US citizen and you are in Zambia, right? That person cannot do it for you. If the person is a friend and not a fiance, maybe you're talking about one second. Maybe you're talking like a visiting visa. So they will still need to do a DS-160 and apply for a visiting visa at the embassy and have to show that they have every single intention and reason to leave the US once their stay in the US is over and have no interest in staying in the US. They need to prove this to the officer at the embassy. These are hard. I am going to be 100% honest with you. If you are coming from an African country, this is going to be a B2 visa, a visiting visa. It's very difficult to get. I am so sorry, but we deal in honesty over here. So if you're coming from an African country, just know it's going to be very hard for you to get a B2 visa unless you have a lot going on for you. And I mean that financially. Okay? So when I say you have a lot going on for you, I mean that financially. Or that your reason for coming to the US is very compelling, that they are willing to give you that. Is there a way to obtain your DS-160 online if you don't have a copy? Whew, no. So you can request a copy of your records from the embassy, so the Department of State. Those requests take time. Sometimes they can take years, and depending on how long ago you did your DS-160, they may not even have the records anymore. So it really just depends. But typically once you leave the application and you don't download it and you go back in, it's not there. If it was a DS-260 for, an immigrant visa versus a non-immigrant visa like the DS-160, it will always be there when you log in. But with the DS-160, once you complete the process, you are supposed to print the application and keep a copy. And then when you log back in, it's typically not there anymore. You can get the confirmation, but not the actual application unless you do a Freedom of Information Act request with the Department of State for those records specifically. Okay. Euphoria is asking, so it's best to be a fiance. Well, if your plan is to marry the person that you are in a relationship with, then yes, that would be your best case scenario over a B2 visa if you, again, do not have a lot going on for you, coming from an African country. And by a lot going on for you, again, I mean financially, right? So, example is a 20-year-old that is in school and does not have a job, but their father is, I'm gonna go with Nigeria. So their father is Dangote. They're going to, which is like the richest man in Africa, right? They're going to get a visa to the US, right? But if you are in the same situation, but you are not working and your father does not have, your family does not have money, the chances of you getting that visa is not great. So that's something to keep in mind. Owning a house is great, but again, there's so much more that goes into it. Have them schedule a strategy session. Let's see if there's enough there to convince an officer. I am very strict with the B2 visas. I'm very honest about them because they are so hard to get if you do not have, employment ties that are really strong or financial ties that are really strong. Okay. Is it impossible? No, but it is harder for some countries than others to get it. All right. So if you have any questions, like I said, go ahead and put them in the comments. If you're watching this on the replay, ask me questions as well. If you would like individual attention to your situation to determine what you qualify for, again, everything I tell you here is just general information. I don't know your particular situation to give you actual legal advice. So the best way to do that is to go to my website, lilylegal.com, click on contact us and schedule a strategy session. You get to pick the date and time that works best for you for us to talk. And that way I can actually give you legal advice in your particular situation. All right. So I hope you have a great rest of your day and a great weekend, and I will see you next week. Bye.